in support of the overarching point that SAREC was entitled to conclude that stay was the right answer. And the third submission focuses on the various features, in particular the features that the Court of Appeal took into account in support of a perceived need for an appeal now, leading in effect to the contention that she must be allowed to return, or return must be facilitated. I start with a position in the camp, the conditions in the camp. That can be answered shortly. That is not, those conditions are not the result of the deprivation, and they will not be affected by the deprivation being overturned or not. The Court of Appeal then relied on the possibility, went straight too far into it because it's the subject of the second part of our appeal, but the prospect that she might be removed to Bangladesh or somewhere else where there were risks of A2, A3 ill treatment. The Court of Appeal relied on that in their judgment at paragraph 116. And our answers to that are that first, she has not been, now over a prolonged period, removed, or indeed threatened with removal of that kind. So any assertion or idea that this is imminent needs to be viewed realistically. And we specifically note in that respect that the Court of Appeal themselves made no finding of imminence, simply that there was, quote, a foreseeable risk that she might suffer ill treatment were she to be transferred. But that finding does not, we submit, undermine the stay. Particularly doesn't undermine the stay because circumstances might change. Her exposure to such a risk was a separate issue and controversial, indeed one of the contested points in the appeal itself. And one cannot proceed, we submit, on the basis that there would not be an opportunity for SAREC to revisit urgently if a stay had been made. We certainly couldn't proceed on the basis that circumstances affecting her ability to participate more effectively in the appeal process would not change, and potentially significantly. And one cannot finally either proceed, we submit, on the basis that even were she to be removed, for example, to Bangladesh, however unlikely that may appear, she wouldn't there have the ability to participate in an appeal and potentially have an opportunity to access whatever it was that was lacking first time round. The overarching point is the same one I've already made, which is that the future is inherently uncertain in a variety of very significant ways. And that affects also the second feature which the Court of Appeal relied upon, or the conclusion that they drew this time at 177 of their judgment, namely that the stay would render the appeal, quote, from their judgment, meaningless for an unlimited period of time. Of course, the effect of a stay is that because of the present issues in the way of a current determination of proceedings, that can't now be done. But a whole host of things, as I say, might happen to enable participation on a more effective basis. The stay simply allows for that. And given that there is no set time limit, the period could not be tied in any event to a certain future event. So saying it was for an unlimited period of time doesn't add anything to the analysis. But a certainty of conclusion is not a prerequisite of a stay in any event in the ordinary terms, unless you can point to some event that you know is going to happen. That is the nature of the stay. But it's all the more important, we submit, that these points should have been thought through fully and properly on the basis of the unacceptability of the alternatives. And that does take one back to the core principle and the core approach. We submit that the court, through either of the ways suggested by my learned friend, allowing the appeal in substance or forcing a return, should not expose the public to additional risk unless absolutely necessary. The existence of uncertainties and various possibilities affecting future participation in appeals undermines any such necessity. And the balance here is, whatever prism you come at it through, the balance here is between public protection and private interest. And that is strongly against a court-directed return, and even more strongly against simply allowing the appeal. And that is so because public protection is the weightier factor in principle. but also because there is no basis for concluding that the risks she poses can be managed in a satisfactory way, no evidential basis for any such conclusion by the Court of Appeal. And the procedural issues which she contends warrant exposure of the public to that risk are both susceptible of the real possibility of change and self-inflicted. So for all of those reasons, we do respectfully submit that the SIAC judgment is to be preferred in terms of its analysis of the intermediate possibility that avoided the extremities of those sorts of outcomes, and that the reasons that the Court of Appeal in effect gave for disagreeing with that conclusion cannot and should not be sustained. My Lords, my Lady, I was going to make very briefly at this stage, recognising that this next bit, although obviously linked in the ways that I've indicated to the points I've been addressing you on, very conscious that the next segment of the submissions, as it were, is on my learned friend's appeal. But I wanted, if I may, just by way of finishing this section, to make 3 or 4 short submissions in relation to the question why it cannot, on any view on our submission, be right to allow the substantive appeal. In other words, to focus on that point. And I take it briefly because, or not least because, we respectfully agree with almost the entirety, if not the entirety, of the Court of Appeal's reasoning in that regard. But 4 short points, if I may. Firstly, the point I've already made, national security is seriously put at risk, plus all of the other points I've made. Secondly, we submit that that outcome, simply allowing the substantive appeal, would represent not an application of justice, but an affront to justice. It would have the effect of bypassing consideration of the substantive issues and, in effect, assuming them in the appellant, in Ms. Begum's favour. And we do respectfully recommend and respectfully agree with the compelling analysis of SIAC in their judgment at paragraphs 144 and 145, including specifically the reasoning in 144, and they're noting that the effect of that outcome would be, as they put it in 145, to convert a right of appeal on the merits into an automatic means of overturning a deprivation decision regardless of its merits, if, for whatever reason, an appellant is unable to take part in her appeal. And I would add to all of that, in circumstances in which she has declined to avail herself of a procedural route, namely the stay, that is available. And recourse to principles of natural justice, which are clear and uncontroversial, does not assist. It does not advance my learned friend's case for the very short reasons and clear and compelling reasons given by the Court of Appeal in their judgment at 107. Third submission is that there is nothing in the legislative scheme focusing on that to support the proposition that problems of this kind should lead to overturning the deprivation decision with all of those national security concerns. Indeed, the indications from the legislative scheme are to directly the opposite effect. The starting point we submit is Lord Justice Law's in the GI decision, or G1 decision, bundle 2 of the authorities, tab 30, page 2115. And the paragraph I want, or the paragraphs I want for this purpose, are 22 and 23 on page 2127. We submit that is the correct starting point for this analysis. That passage, those paragraphs were, you might like to note, adopted by the Court of Appeal and relied on by them in the SI decision, or S1 decision, Bundle 3, tab 46, page 261, Lord Justice Burnett, at paragraph 71 for this purpose, adopting the paragraphs in GI, and that's page 2627, para 71 of Lord Justice Burnett. We submit that the analysis, which I won't do justice to, so I'll only summarise, but the analysis, the detailed and comprehensive analysis of SIAC on this point is very powerful indeed. See paragraphs 145 to 152 of their judgment. And the key features of that analysis, if I can try and summarise them very shortly, were firstly that Parliament knew full well that there would be a quantity of appellants against deprivation decisions who are deprived of nationality on national security grounds and are abroad, including in the variety of terrorism and conflict hotspots, and will therefore have difficulties of communication in precisely this sort of circumstance. Secondly, Parliament deliberately removed the suspensive effect that had been in section 40 sub 6, no deprivation order whilst the appeal could be or was being brought against the notice of intention to make such an order. And so the Secretary of State, by that change, that deliberate legislative change, was left free to make an order so that it took effect immediately, irrespective of the exercise of appeal rights, balancing, in essence, in favour of immediate impact in terms of the order. And thirdly, highlighting and emphasising the particular importance of national security in these sorts of cases. So there would, for example, be no frustration of statutory purpose, even if you deliberately waited on national security grounds, knowing before someone left the jurisdiction, knowing that the effect would be to deprive them of an in-country right of appeal. I took you to Lord Justice Laws in L1 earlier, paras 25 and 26 at page 2350, about the dominant importance of national security in this sphere. And again, that also was noted and relied on by Lord Justice Burnett and the Court of Appeal in S1, this time at paragraph 69 on page 2626. And we would also invite you to note the whole of that paragraph, 69, where Lord Justice Burnett analyses the practical difficulties that any sort of principle that must be satisfied at the time of decision you can ensure a fair and effective appeal at that time would give rise to. So the inference properly drawn from the statutory scheme by SIAC in their judgment at 151 is that Parliament recognised that appeals would often be brought from outside the UK. Some at least would face very significant restrictions on participation in those appeals. And indeed, the logic of the argument means that the more committed, the more extreme an individual is, the more likely it is that he or she could not engage in that process. And thus, if they're right on this case, that the deprivation order would have to fail on procedural grounds. I return to the point, is the consequence of those restrictions ultimately, and we are not ultimately yet because of the possibility of a stay, is the consequence of those restrictions ultimately that an appeal on the merits succeeds without any examination of the merits, or that the deprivation order stays in place? That's the ultimate question. And SIAC was right, we respectfully submit, to conclude that were that point to be reached, those features of the statutory scheme powerfully suggest that the order would stay, and that SIAC would have to do the best it could or to wait. That's the third submission. The fourth submission is that there is nothing in authority in the cases to require that a substantive appeal be allowed in such a case. Indeed, the case law, most of which I've taken you to or referred you to, and that was analysed in the SIAC judgment at 153 to 166, especially 158 and 166, G1, L1, S1, all of those positively are against that sort of outcome. The case on which my learned friend placed principal reliance, at least in the Court of Appeal, was the W2 case, or Justice Beatson in the Court of Appeal. That's in the bundles at 2923, bundle 4, tab 55. I don't invite you to turn it up. It was dealt with in the SIAC judgment between 175 and 190. And it was dealt with in some detail also by the Court of Appeal at paragraphs 100 and following. And we respectfully agree with both courts' analysis of the W2 decision. We also agree with the Court of Appeal, paragraph 110, about whether or not some case law under the TPIM or control order regimes truly advances this issue. We respectfully agree for the reasons that they there set out. I think the case of AN was relied upon, electronic 1840. But we respectfully agree both with the Court of Appeal and with SIAC, Court of Appeal 110, SIAC 172 to 174, that those cases don't assist either. Finally, we agree with both the courts below that the international legal position doesn't add anything and does not advance the proposition that in circumstances such as this, the substantive appeal needs to be allowed, essentially for the reasons given by the Court of Appeal at paragraph 108 to 109. You don't need me to go back on the various constraints on the reception, even of customary international law, into domestic law, been dealt with very frequently by this court, not least by Lords Neuberger and Mance in the KU decision. The customary international law, even at that level of customary international law, is not automatically part of domestic law, but it can shape it, and there may be a whole variety of constitutional difficulties with simply introducing it. But the position doesn't need to, the stand, as it were, doesn't need to be taken there, because whatever else may be the position, as a matter of international law, what is needed if an attempt is made to rely upon provisions of international law is precision of issue. And as I make the submission, Lord Lloyd Jones's judgment in the Al Sadoun case comes to mind, where reliance was placed on the Torture Convention, and there was a general, and it might be thought rather airy, submission being made by Mr. Fordham that torture was a bad thing and was part of its prohibition was part of customary international law. And the answer that the Court of Appeal and or Justice Lloyd Jones, who then gave, was to say, no, if what you're trying to rely upon the Torture Convention for is the establishment of an obligation to conduct an independent inquiry under domestic law, then you need to demonstrate the customary nature of that proposition as a matter of international law. That's what I mean by precision of issue is required. And none of the provisions relied upon by any of the parties do that or come close to establishing that there is a principle of international law that in a context such as this, the substantive appeal must be allowed. So those are the submissions on a fair and effective appeal. And I was going to turn, if I may, finally to the Article 2 and 3 risk submissions, unless there is anything further I can assist you on in relation to the fair and effective appeal issue at this stage. My lords, my lady, then the Article 2 and 3 risks position, and I start with the legal approach of the courts to this sort of issue, and 3 points to note in relation to that. Firstly, we are here dealing with the application of what's been variously described as a practice or policy. the background and nature of that practice or policy was dealt with in the X2 case, and that's in bundle 4 of the authorities behind tab 57, electronic 2977. And the paragraphs I want start on page 2979. And they are paragraphs 9 through to the end of 13, which I would invite the court to read if you would. 2979. Paragraphs 9 through the end of 13. So you'll see the nature of the policy or practice. This was almost illustrated as a policy or practice as such because of its development and refinement over time. And all of this happens well before our relevant decision making in February 2019. So it's set by this stage, but you will see that it's been firmed up, if that's the right way of describing it, so that there is a very clear emphasis on it being the direct consequence of the decision to deprive. That's the emphasis one sees 4 lines up from the bottom of paragraph 12, penultimate line of paragraph 12, first line of paragraph 13. And also, see about 2/3 of the way down paragraph 13, the sentence, the Secretary of State will not ordinarily give substantive consideration to the risks that may arise, and so on. That the Secretary of State won't ordinarily consider mistreatment in another country where they're not currently located. And that is why in our case at paragraph 64, in fact you should turn it up now, but 142 is the reference we summarised, hope accurate and hope in crisp form, as it were, the nature and effect of paragraphs 9 to 13, this summary in X2. And of course, given that we're dealing with a practice or policy, a framework under which the courts exercise their powers to control the lawfulness of decision-making is the framework of public law applicable to any practice or policy. And on that set of principles, the application of the policy, whether it's engaged on particular facts and how it applies, or indeed whether to make an exception to the policy, which all policies admit of course, is a matter for the Secretary of State as the primary decision maker, controllable in the ordinary way by rationality and public law principle. That's the first point. Second point is that we're not here dealing with a case in which the European Convention on Human Rights, incorporated through the HRA, is in play so as to impose an obligation not to act incompatibly with the scheduled rights under Section 6 of the HRA. And that is because Ms. Begum is not within the jurisdiction. So there's no question of Section 6 of the HRA applying, or of the court deciding is the action unlawful under that jurisdiction. Indeed, this is the premise for the debate of principle that arises. And thirdly, you don't create a situation in which the thing is akin to Section 6 of the HRA applying by using Article 2 or 3 shorthand to describe the content of the practice or policy we've seen described in some detail at paragraphs 9 to 13 of X2. I mean, suppose, for example, the policy had said, we've got no ECHR obligation, so we decide that our practice will be not to deprive unless it is certain that they will be ill-treated as a result in the country in which they currently sit. It would be clear how the court would approach that, and using the A2, A3 shorthand doesn't affect that. It's still the nature of it, it's still a practice or policy. And we respectfully submit on the back of that that the approach of SIAC to this issue was correct. Rationality is the standard, policy posing a question of fact, that question of fact being for the decision maker to decide for himself, was this the direct consequence, not ordinarily considering the position of other countries, was this the direct consequence of the deprivation? And it makes no difference, we submit, that you can appeal from the Secretary of State about deprivation to SIAC, and that their jurisdiction is, on the face of the statute, an appellate jurisdiction. It's entirely possible to have an appellate jurisdiction in which you're applying the substantive principles of public law. The question is, what is the issue? And the issue, we submit, properly analysed, is whether or not the Secretary of State rationally operated her policy. The fact that it's an appellate jurisdiction doesn't suddenly alter or fundamentally change the underlying nature of the law. This is about the principles that are to be applied, and that isn't altered by the fact that this is an appellate jurisdiction that SIAC is exercising, as SIAC rightly appreciated. The question, as I say, on appeal was whether the Secretary of State had lawfully applied his policy. It was a him then. It was not whether the deprivation decision would breach Articles 2 or 3. And that's a critical point of distinction. SIAC was not charged with examining, in effect, a Section 6 HRA complaint. But we see that from the distinction, for example, that is drawn in the legislation itself. It had to examine whether the Secretary of State applied his own practice. And that meant that the correct principles were those identified by SIAC here, and indeed in X2 itself. And that is illustrated by the fact that you approach it, and SIAC approached it and tested it on the basis of the decision before the decision maker, or the material that the Secretary of State ought reasonably to have considered at that date. And they summarised accurately the ministerial submission at 131 to 134 of their judgment. There was nothing wrong with that. The Court of Appeal relied, in parenthesis, as it were, on the Evans decision, where a similar policy was applied in relation to the transfer of those who were detained by British forces in Afghanistan and were or were not to be transferred to the tender ministrations of the Afghan authorities. Evans is at 1969, and the relevant paragraph for present purposes is paragraph 240 at page 2019. We respectfully submit in relation to Evans, firstly, that there was really no difference on the facts, depending upon which approach you took on the facts of that case, whether it was a public law approach or not. And for that reason, the point was not really argued and was simply noted, as you see from their judgment. No reasons were given by the court for the view expressed. It was a different context in any event, but if necessary, we respectfully submit that that particular part of an otherwise entirely impeccable judgment was wrong, for the reasons of principle that I've given. That's what I say about the approach. Those are my submissions on the approach that is to be adopted. SIAC was right and the Court of Appeal respectfully were wrong on that issue. In any event, however, There was no error in relation to considering the position on the basis that the key focus was on Syria and the risks faced by Ms. Begum as a direct consequence of the deprivation decision in Syria, and not in other countries to which she might or might not travel in the future. Consideration of whether or not a deprivation decision, a particular deprivation decision, gives rise as a direct consequence to those sorts of risks does not require, probably under A2 and A3 in any event, but certainly on a self-defined practice or policy, the chasing down of all future risks. It involves sensibly considering the immediate risks in place and the circumstances that the person then is in, here in Syria. There's no requirement in the practice for any such inquiry. Indeed, the description of the practice in paragraph 13 of X2 is powerfully against engaging in that sort of speculative exercise. The conclusion in relation to Syria and the risks in Syria were contained in subparagraph or paragraph I of the open ministerial submission, and that is in the core volume at paragraph 37, at page 370, electronic 370. Bottom of the page. And we submit in relation to this ministerial submission and the analysis of risks in Syria that the conclusions of fact that SIAC reached about this issue at paragraph 139 of its judgment were conclusions that it was entitled to reach. There was nothing to suggest that the direct consequence, to use that phrase, of the deprivation decision would be to put her at risk. You test that against the risk she faced before she was deprived. There's no evidence to suggest that she would have been or has been treated any differently as a result of the deprivation, whether in terms of her detention or any purported risk of onward removal to Bangladesh or anywhere else. Nothing to suggest that those have altered or increased as a result, a direct consequence of the deprivation. She is in detention in Syria. She would remain in detention in Syria whether she's a British citizen or not. And the Secretary of State has got no control over that fact of detention. So far as the risks outside Syria are concerned, we submit that they are wholly speculative, that applying the practice that you've seen described where the Secretary of State has said in terms, I will not ordinarily engage in that speculation, that was entirely appropriate and a matter for the Secretary of State in terms of determination and illustration of the policy or practice. Those sorts of things in this sort of context are inevitably highly uncertain, given the myriad of possibilities of what might occur in the future, including, for example, the possibility of the camp system simply disintegrating in the chaos of that country and people crossing the border into Turkey or doing whatever. There are massive things that could happen. And again, we submit that SIAC, in drawing the conclusions it did at 139 of its judgment of fact, were entitled to reach those conclusions. There was no proper basis for disagreeing with them. And they reflected the conclusions in the analysis in the annexes to the open ministerial submission. For this purpose, the relevant ones are Annex C and Annex D. Annex C starts at page 373. see paragraph 5 in relation to Syria, see paragraph 6 and 7 in relation to Bangladesh, and then if you go over into Annex D, which starts on page 374, see paragraph 4, Roman 3 on page 374, and for example, paragraph 21, as to Bangladesh, the risk was in fact considered, paragraph 6 and 7 of Annex C. The the Secretary of State was given an overview of those risks, but the conclusion based on all of the material, including for this purpose Annex D, paras 10 and 11, was that this would not be the direct consequence, and there wasn't any reason to break the usual rule, which is they're not going to explore the speculative possibility of transfer to other countries. And it is to be borne in mind, perhaps, that the available evidence demonstrates that the Bangladeshi government doesn't want her back anyway. It's clear that they won't be seeking her return, and any prospect of return to that country would have to involve volition on their part. And either she or they are, neither of them are going to do that. That doesn't mean she's got nowhere to go. The position is fluid. And finally, in relation to Iraq, again, that was considered in the ministerial submission in general terms, but there's no evidence at all in her case of risk to her. The evidence she relied on below was all focused on the position in Iraq with trials there and sentences there, possible sentences. But there's no evidence that there was any intention of the SDF or anyone else to send her. She's got no prior connection with Iraq. And so again, that part of it is entirely speculative. But the overarching point I make and repeat is that this is the application of a practice or policy which is carefully defined to shut the door in almost all cases to this sort of speculation, and which emphasizes the need for it to be a direct consequence of the deprivation, not a possible outcome if LTE is not granted for a return to the United Kingdom to participate in an appeal. That's what this set of issues is concerned with. And we respectfully submit, therefore, that the analysis of SIAC at 139 in particular was both right in principle and open to them on the facts. My lords, my lady, those are my submissions.
Thank you very much, Sir James. In that case, we can turn to Lord Panic.
Thank you very much, my lords, my lady. On behalf of Ms. Begum, I'm going to address the fair and effective appeal points, and Mr. Hickman is going to address the Article 2, Article 3 issue. In relation to the fair and effective appeal question, the case for Ms. Begum can be summarised in the following propositions. First, as SIAC found, Ms. Begum, quote, cannot play any meaningful part in her appeal, unquote. That's what they found at paragraph 143, which is EF 348. That was
you may have omitted the words that Sir James emphasised.
I'm going to deal with Sir James's temporal point. I'm going to submit that that was true both when SIAC decided the case on the 7th of February this year, which was almost a year after Miss Begum arrived at the Al Roj camp. She'd been there for almost a year when SIAC gave its judgment, and I'm going to submit that it remains the case now, in answer to Sir James's point on the material that the court has, and there's no reason to think that it's not going to remain the case for the foreseeable future. That's the first submission I'm going to develop. The second submission that I want to make on behalf of Ms. Begum is that she has a statutory right to a meaningful appeal, which in our submission is not subject to any relevant national security exception. I say relevant, my lords, my lady, because Parliament has intervened to protect national security information from disclosure. And it's done so by specific statutory provisions, the details of which don't matter, and to which Sir James has already mentioned the special procedures of SIAC, the use of special advocates, matters of that sort. So Parliament, when it thinks that the statutory right of appeal should be affected by national security considerations, has said so expressly. And we say that national security considerations are not an answer, cannot be an answer to the right to a meaningful right of appeal, especially when the very purpose of the appeal to the independent tribunal, SIAC, the purpose is to enable that independent tribunal to assess the strength or otherwise of the national security concerns which are identified today by Sir James. And the purpose of the appeal is to enable SIAC to assess the strengths and weaknesses of those arguments in the light of the evidence that is adduced on behalf of Ms. Begum and the arguments that are advanced on her behalf in the light of her instructions. And therefore to allow national security considerations to deny Ms. Begum access to a meaningful right of appeal is indeed, as the Court of Appeal put it, it's paragraph 94 of their judgment, to put the cart before the horse. So we say, both because Parliament has not created any national security exception, and because to recognise such an exception cuts across the very purpose of the appeal, we respectfully submit there's no question of a balance here, if balance is the right word. Sir James's argument is rather national security is a matter for the Home Secretary, and the court, other than the most exceptional circumstances, can't take a different view. But we say there's no question of balance here. We say the Secretary of State cannot maintain a decision to deprive Ms. Begum of her citizenship unless a means can be found to confer on her, without unreasonable delay, a meaningful opportunity to appeal. That's what Parliament has given her, advisedly. And leave to enter is the only effective such means available. That's the second head of submission that I want to make on her behalf. The third point I want to make is this: even if that second submission does not find favour and a meaningful opportunity to appeal can be affected by national security considerations, that there is some form of balancing exercise, we say that the Court of Appeal struck the balance in the correct manner for reasons that I will seek to develop. And our answer to the question that was posed this morning by my Lord the President to Sir James is that the challenge to the refusal of LTE in this statutory context is not a rationality challenge. The court's task, we respectfully submit, is to assess what procedural fairness requires. LTE is a means, we say the only effective means, to ensure procedural fairness to Ms. Begum in the unusual circumstances that arise in this case. And the demands of procedural fairness are elementarily a matter for the court to decide, not for the Secretary of State to decide, subject only to a rationality challenge. I will, of course, seek to develop each of these propositions, my lords and my lady, but that's the thrust of the case for Ms. Begum. Can I start, though, by emphasising the context in which these issues arise, the statutory context in which they arise. Sir James began with a factual context, as he puts it, for the Secretary of State. But the statutory context, we say, is of vital importance. The power to deprive a person of British citizenship is one of the most severe powers that Parliament has conferred on the Home Secretary. And indeed, Sir James recognised that, he accepted that, he said it's not in dispute. A deprivation power is far more serious in its consequences for the individual than most criminal penalties. And this was recognised by Lord Wilson for this court in the Al Jeddah case. Could I ask the court to turn up page 1717, volume 1, tab 16, although I'll stop giving those references because I think I'm the only person who's using them. Page 1717. Lord Wilson speaking for the court, and his lordship addressed deprivation of citizenship, the basic principles, under the heading of statelessness at page 1726. And at page 1727, his lordship referred in the third line of the page to the Universal Declaration of Human Rights, Article 15, that everyone has the right to a nationality and that no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality. And at letter C, his lordship referred to the celebrated judgment, dissenting judgment, albeit, of Chief Justice Warren in the United States Supreme Court. A right to nationality is a man's or a woman's basic right, for it is nothing less than the right to have rights. And that is, of course, because other rights flow from nationality, in particular, a right to enter and reside in the country of your citizenship, and if you're abroad, the right to consular protection. It is then unsurprising that Parliament has conferred on a person who is subject to a deprivation decision a right to have that decision to deprive them of their nationality redetermined on the merits by an independent tribunal, either the first tier tribunal, or if it's a national security case, SIAC. And it's our submission that that right of appeal is integral to the statutory regime for deprivation of citizenship. It is the essential safeguard which Parliament has thought necessary. Sir James referred to the statutory provisions. Could I just ask the court to look at them so I can make some points? Your lordships, your ladyship, find the relevant provisions behind tab on page 1495. That's the current version of the British Nationality Act 1981. And could I invite attention, first of all, to section 40, which appears on page 1498. And the court sees that in section 40, subsection 2, the power of the Secretary of State to deprive a person of citizenship if the Secretary of State is satisfied that deprivation is conducive to the public good. Subsection 3 confers an additional power if there's if registration or naturalization has been obtained by fraud, false representation, or concealment of a material fact. Subsection 4 provides that a deprivation order may not be made if the Secretary of State is satisfied the order would make a person stateless, and that needs to be read with section 40, subsection 4A. That does not prevent the Secretary of State from making an order to deprive a person of citizenship status if that results from naturalization and the person has acted in a manner seriously prejudicial to the vital interests of the country, and the Secretary of State has reasonable grounds for believing the person is able to become a national of another country or territory. And this is relevant, my lords, my lady, on the national security case, because when I come to that, I shall point out that in other than exceptional cases, of which this is one, where it is said that the British citizen has another citizenship, the Secretary of State cannot take their citizenship away, and however grave a threat they may pose to national security, they can only be dealt with by means of criminal prosecution or TPIMs, or some other administrative measure, asset freezing, something of that sort. And I'll come back to that. I also want to draw attention to section 40, subsection 5 on page 1499, which indicates for the first time Parliament's concern to maintain procedural fairness in this context. Before making an order under this section in respect of a person, the Secretary of State must give the person written notice specifying that the Secretary of State has decided to make an order, the reasons for the order, and the person's right of appeal under section 40A1, or in national security cases, Section 2B of the SIAC Act 1997. These provisions, Section 40 and Section 40A, as the court sees from the note near the bottom of the page, were substituted in 2002. The deprivation power had previously been accompanied by a right for a person to refer a proposed deprivation decision to a committee of inquiry that was presided over by a judge. And Parliament gave specific consideration to this question in 2002, and it decided that a right of appeal to either to the first tier tribunal or to SIAC was more appropriate. One then sees over the page the provisions of Section 40 capital A. Subsection 1 confers a right of appeal to the first tier tribunal, but subsection 2 disapplies that, where the Secretary of State certifies that the decision was taken wholly or partly in reliance on information which, in his or her opinion, should not be made public, in the interests of national security. There are two other grounds there. So Parliament has decided that there is a right of appeal. Parliament has decided to which body that right of appeal goes, and it has decided, for obvious reasons, that where national security issues are involved, the appropriate body is SIAC, and that is because SIAC, through the detailed rules and regulations and provisions, has the ability to consider the national security issues in conditions that maintain the confidentiality of that material, both from the public generally, but more specifically from the applicant, the appellant herself, and the use of the special advocate procedure. Now, there is no dispute, as I understand it, that these appeals, whether it is an appeal under Section 40 capital A1 or 40 capital A2, the appeal to SIAC, is a de novo redetermination of the issues. SIAC, in the national security case, hears both sides. It may, invariably does, hear evidence which is distinct, different from the evidence that was before the minister when she took her decision, and SIAC forms its own view. This was stated in a helpful judgment decision for SIAC by Mr. Justice Mitting in Al Jeddah, which the court will find at page 1633. And his lordship for SIAC set out the issues in that case at 1635. And the first issue, paragraph 2 on page 1635, the first issue that his lordship identified was, should the Secretary of State's decision is conducive to the public good, deprive the appellant of his citizenship, be upheld. And further down, his lordship said this first issue raises important questions about the approach which the Commission should take to the Secretary of State's decision. Over the page 1636, at paragraph 4, we see the reference to Chief Justice Warren's observation. His Lordship says Parliament could have legislated the decision should be that of a member of the executive alone, subject only to an appeal to a judicial body whose powers are, if Mr. Swift is right, in substance, if not in form, limited to those of judicial review. The question is whether or not it has done so. And his Lordship answered that question in the negative. We see that at 1637, 4 lines up from the bottom. This is paragraph 7, 4 lines up from the bottom of the page. An appeal is a challenge to the merits of the decision itself, not to the exercise of a discretion to make it. And then over the page, paragraph 8, his Lordship referred to a judgment of Lord Wolfe in the 4th line, the 2nd sentence. The constitution and procedures of SIAC have been established to permit an exhaustive inquiry to be made into the Secretary of State's reasons for making decisions about national security and related issues. And then near the bottom of the page, some 10 lines up from the bottom, there's a new sentence on page 1638, 10 lines up from the bottom. The principal issues on national security are invariably what has an appellant done and what inference can be drawn from his or her past actions and current capacity and beliefs about the threat, if any, which he or she poses to national security. These are matters of individual assessment, which the Commission is particularly well placed to make. Indeed, its procedures almost certainly ensure that the case of an individual appellant is subjected to greater scrutiny than could be given to it by the Secretary of State.
Can I just put a point to you, Mr. Lord Panic? What's said in this paragraph? For example, you'll see a little bit above where you began, you'll see a sentence beginning, great weight is always given to the assessment of the Secretary of State.
Yes.
But the Commission has not felt inhibited from differing from their assessment if persuaded that it is wrong. And then they cite Lord Flynn to the effect that the Commission must give due weight to the assessment and conclusions of the Secretary of State. What strikes me is that it may be going too far to say that the appeal is a de novo redetermination of the issues. It rather sounds as though it is a conventional appeal. It's a challenge to a decision which SIAC can interfere with if persuaded that it's wrong. And so the question is there an error demonstrated in the Secretary of State's assessment? Not applying judicial review principle, no, but applying the ordinary approach of an appellate body.
Well, I wouldn't disagree with that. De novo then is the wrong expression for me to use, but I'm anxious to emphasise, and I don't think your Lordship question suggests to the contrary, that it's not a judicial review test. No, it is plainly the case that when SIAC assesses whether or not the Secretary of State has reached the wrong answer, the Commission is very mindful, of course it is, of the expertise that the Secretary of State has through her officials. She has a panoramic view, she has expertise, she has experience, but nevertheless, the Tribunal's task is not just to assess the material that was before the Secretary of State, it is to look at all the material, which invariably will be different material than was before the Secretary of State, and its task is to form its own judgment on the rights and wrongs. It doesn't simply accept the say-so of the Secretary of State unless there is perversity or some other public law error. So it is a fact-finding body in that sense. Its responsibility is to find the facts as it sees them. And the relevance of this is as to the nature of the statutory protection that Parliament has thought it right to confer on the individual whose citizenship is being taken away by the Secretary of State. So it's an independent assessment by an independent judicial body, which of course over time has developed expertise of its own. It doesn't come to these issues afresh. It has in those who sit on SIAC a fund of experience and expertise that enables it, SIAC, to form its judgment, taking account, as I say, of course, of the expertise of the Secretary of State. And the point was,
I'm sorry to interrupt, but if this is going to matter, that we understand precisely what the nature of a jurisdiction exercised by SIAC is, we may need to look at authority on that, perhaps beyond the current decision by SIAC you've put in front of us. I mean, it has been looked at certainly by the House of Lords, if not by this court.
Well, it has. That I'm coming to the Al Jeddah case in your Lordship's court.
Fine.
But I thought it right just to show the court what was said in SIAC. Lord Wilson addressed the point for this court in the Al Jeddah case, which the court will find at page 1717.
Yep.
And his Lordship addressed this issue at paragraph 30, which is on page 1732. This is in the context of a decision as to statelessness, but the point is a general one. Lord Wilson says at 1732, paragraph 30, that the Secretary of State places great weight on the word satisfied within the terms of the prohibition in section 40, subsection 4 of the Act, against making an order for deprivation if she is satisfied that the order would make a person stateless. In providing for her satisfaction in this regard, the subsection replicates the requirement in subsections 2 and 3 that she be satisfied of the existence of one or other of the two grounds for making the order, and the court has seen those grounds, the national security ground in particular. The word satisfied in the subsections should, if possible, be given some value. I confess, said Lord Wilson, however, that his Lordship did not find it easy to identify what that value should be. Parliament has provided a right of appeal against her conclusion that one or other of the grounds exist, and or against her refusal to conclude that the order would make the person stateless. And it has been held and is common ground that such is an appeal in which it is for the appellate body to determine for itself whether the ground exists and or whether the order would make the person stateless, albeit that in those respects it may choose to give some weight to the views of the Secretary of State, and not simply to determine whether she had reason to be satisfied of those matters. And there's a reference to a Court of Appeal judgment, Lord Justice Jackson. And then there was the submission for the individual that the court should go further than that. And at paragraph 31, Lord Wilson says the word satisfied adds nothing to it. The Secretary of State's argument still remains that section 44 requires the active or real cause of any statelessness to be identified. And that, I think, is dealing with a different point. So that's the ruling in your lordships and your ladyships courts. Lord Wilson addressing not just the issue of statelessness, but determining the way the matter should be approached in relation to all the elements of the determination, particularly whether the Secretary of State has good national security grounds for depriving the individual of their citizenship. That's my submission in relation to that, repeating as I do that I accept, to use Lord Wilson's words just above letter G, that SIAC not only may, but will inevitably choose to give weight to the views of the Secretary of State. I don't suggest that those views are irrelevant, far from it. And that was the same case as Mr. Justice Mitting was deciding. The matter was not in dispute in this court. Now, we then submit that it is a basic principle with respect of administrative law that Parliament is presumed to intend that an appeal right which it has conferred should be a fair and effective appeal right, unless Parliament has clearly indicated to the contrary. Again, there's a statement by Lord Wilson which assists in this respect. It's in the Chiari case, which Sir James mentioned this morning. The court will find it at page 2307 of the authorities. And this was in the context of appeals against deportation of foreign criminals. And the general principle that Lord Wilson expressed appears at paragraph 35 . And it's at letter E, where Lord Wilson is addressing public interests. And Lord Wilson says on page 2320, paragraph 35, letter E, his lordship refers to the public interest that when we are afforded a right of appeal, our appeal should be effective. I say that's a statement of the obvious, but it's helpful in my submission to have some authority for it. We also rely, as a general proposition, on the principle stated by Lord Wilberforce long ago in Wiseman and Bournemouth, which the court has at page 2952, the tax case Wiseman and Bournemouth, and the relevant passage is dealing with procedural fairness. And Lord Wilberforce, in a passage oft cited at page 2972, his lordship's speech begins at page 2972 at letter C, and in the new paragraph just under letter F, his lordship says that he's not satisfied with an approach which merely takes the relevant statutory provision subjects it to a literal analysis and cuts straight through to the conclusion that Parliament has laid down a fixed procedure which only has to be literally followed to be immune from attack. It is necessary to look at the procedure in its setting and ask the question whether it operates unfairly to the taxpayer to a point where the courts must supply the legislative omission. And over the page, at page 2973, letter C, His Lordship says the legislature may certainly exclude or limit the application of the general rules, that's the rule of fairness that I've just read, but it has always been insisted that this must be done clearly and expressly, and His Lordship cites authority for that proposition from Australia and then from Canada. And as I've already indicated, the issues in the present context arise where Parliament has expressly excluded what would otherwise be principles of fairness, natural justice, upon which the subject of a deprivation decision would rely. That is, that they must be entitled to see all of the evidence that is adduced against them. Parliament has expressly provided by a series of provisions that that is not the case. But Parliament has not made any provision excluding otherwise the basic rights to an effective right of appeal within the confines of the SIAC procedure. And we do submit that given that Parliament in this context has made express but carefully circumscribed derogations from procedural fairness in relation to deprivation appeals, it would be wrong in principle with respect for the court to imply additional restrictions and limitations into the statutory scheme and the right to an effective appeal which Parliament has expressly conferred. The Court of Appeal in the present case did address this fundamental issue, and it is a fundamental issue, and they addressed it at paragraph 112 of the judgment, which is at page 281 of the appendix, page 281. And at paragraph 112, they say in the second sentence, with due respect to SIAC, it is unthinkable that having concluded that Ms. Begum could not take any meaningful part in her appeal so that it could not be fair and effective, she should have to continue with her appeal nonetheless. I'll deal later, if I may, with the suggestion that Sir James emphasised that perhaps he says there should be a stay. He's not asking for the appeal to proceed. But that's the starting point, that Parliament cannot have envisaged that in circumstances where Ms. Begum could not take any meaningful part in her appeal, an appeal could proceed. And the Court of Appeal returned to this at the next page, page 282, paragraph 113, where they say it's one thing for an appeal to proceed without the participation of the appellant against an appellant who chooses not to participate, and that's not our case, of course. Ms. Begum wants to participate. It is quite another to proceed with an appeal without the participation of the appellant because the appellant is unable to participate meaningfully and effectively. Far from remedying the unfairness, this would seem to compound it. As Lord Justice Singh said in the course of argument, it is difficult to conceive of any case where a court or tribunal has said, we cannot hold a fair trial, but we're going to go on anyway. I respectfully submit that must indeed be so. There are cases in other contexts where the courts have said at a very high level of authority that detriments cannot be imposed on individuals who have a right of appeal if they can't participate, or who have a right to a trial if they cannot participate in the trial where their absence is involuntary. For example, it may just assist the court to see Lord Bingham's statement for the Appellate Committee in volume 2 of the authorities. It's page 2196. The Queen against Anthony Jones, 2196, and the relevant passage in Lord Bingham's speech is at paragraph 13 on page 2208, the Lords, my lady, page 2208, paragraph 13, just under letter C. His Lordship says, speaking for the Appellate Committee, if the absence of the defendant is attributable to involuntary illness or incapacity, it would very rarely, if ever, be right to exercise the discretion in favour of commencing the trial, at any rate, unless the defendant is represented and asks that the trial should begin. That's the general principle in criminal law. And the board has adopted the same approach in a medical disciplinary case, which I don't need to ask the court to turn up, but it's the case of Tait, T-A-I-T, which appears at page 2810. It's a Privy Council case in 2003. Now, the courts are not unfamiliar with the profound dilemmas that are posed by a conflict between procedural fairness and national security. This issue has arisen in the last few years, sadly, as a result of current events. It has arisen on a number of occasions. And I remind the court, it doesn't need reminding, but I remind the court that that was essentially the issue in the Al Rory case, which can be found at page 1735, where the issue, as the court well recalls, was whether or not a closed material procedure could be adopted by the court to determine proceedings that raised national security issues in the absence of any express parliamentary authority for such a procedure. And the answer given by this court was no. That cannot be done. The court so decided by a majority. Lord Clark dissented on that issue. The issue was moot by the time it came to this court. See Lord Dyson at page 1775, paragraph 7, where his lordship explains that the court had decided nevertheless to decide the point because of its importance, the importance of the point. Lord Dyson addressed this issue at paragraph 22, which is on page 1779, And his lordship, Lord Dyson, giving the first judgment in this court, said at paragraph 22, page 1779, it is surely not in doubt that a court cannot conduct a trial inquisitorially rather than by means of an adversarial process, at any rate not without the consent of the parties, or hold a hearing from which one of the parties is excluded. These admittedly extreme examples show that the court's power to regulate its own procedures is subject to certain limitations. The basic rule is that, subject to certain established and limited exceptions, the court cannot exercise its power to regulate its own procedures in such a way as will deny parties their fundamental common law right to participate in the proceedings in accordance with the common law principles of natural justice and open justice. To put the same point in a different way, the court must exercise the power to regulate its procedure in a way which respects these two important principles, which are integral to the common law right to a fair trial. And I would say similarly in relation to a statutory right of appeal. And it is, in my submission, nothing to the point that there may be, indeed were in that case, powerful arguments as to national security, why, without a special procedure, the position of the security service was quite impossible. That was the argument. Unless we have a special derogation from what is otherwise a procedural fairness, the case cannot be tried. And the problem was addressed in what, in my submission, was the appropriate constitutional way of addressing the problem, which is that Parliament enacted in 2013 express statutory provisions that address this problem. And I say to the court that if the result of this case is considered by the Secretary of State to be a result that damages national security, she is of course perfectly entitled to put before Parliament such legislative proposals as she thinks appropriate for Parliament to consider to address the problems of national security, which Sir James most eloquently addressed this morning. Other members of the court in Al Rory spoke to similar effect. I won't take time on it, but I draw attention to Lord Hope at paragraph 72, Lord Brown at paragraph 84, and Lord Kerr agreeing with Lord Dyson at paragraph 88. That's not, of course, the only context where this profound conflict between procedural fairness and national security has arisen in recent years. The problem has also arisen in the context of what were control orders and what are now TPIMs. And the courts heard argument on the fundamental issue of whether, as the Secretary of State contended in a series of cases, for national security reasons, the subject of a control order could be denied even basic information about why he, and it's normally a he, is being made the subject of such an order. And the Secretary of State's argument was that procedural fairness is all well and good, but it must give way to national security, of which the Secretary of State is the best judge, because otherwise the security of the country cannot be protected. That was the argument, and it failed. And it failed in particular in the AF case, and this is all very familiar to the court, so I'm not going to labour the point, but the court has AF number 3 at page 1 529, where the decision was made in AF by the appellate committee. I mentioned that for those who are interested in distinctions between the appellate committee and this court, but the decision made by the appellate committee in 2009 was that the Secretary of State simply cannot make a control order without providing to the subject of that order basic information about why he was being made the subject of such an order, whatever the national security implication. And if the Secretary of State was not prepared to disclose, as natural justice required, that information, then the control order couldn't be made. So again, it's a very good example of the courts at the highest level not accepting the argument that procedural fairness, basic rights to procedural fairness, must give way to national security concerns. However important those concerns are, and they are very important to public policy, they do not take priority, in my submission, on authority over procedural fairness in context where Parliament has conferred rights to either to an appeal or a review or some other procedural guarantee as the a procedural guarantee of the interests of the individual against whom such important sanctions and protections are adopted. I also mentioned, in answer to the question posed this morning by my Lord the President, that it's the role of the court, it's the duty of the court, it's the power of the court, it's the function of the court to decide for itself what procedural fairness requires. It's not a perversity issue. The authority for that is the Osborne judgment of my Lord the President for this court. If I could just remind the court, it's very familiar to the court, of course, but can I just remind the court of what was said in the relevant paragraphs? It's at page 2478. Osborne begins at 2445, but at 2478, my Lord the President, speaking for this court, addresses this fundamental question at paragraphs 64 and 65. Your Lordship said at 2478 paragraph 64 that it was necessary to begin by considering the practice followed by the board, that's the parole board, in the light of domestic principles of procedural fairness. And your Lordship said it may be helpful, it was helpful, to clarify matters at the outset. And the first matter, your Lordship said, concerns the role of the court when considering whether a fair procedure was followed by a decision-making body such as the board. Your Lordship referred to a decision in that case of Mr. Justice Langstaff, who refused the application for judicial review on the ground that the reasons given for refusal to hold an oral hearing are not irrational, unlawful, nor wholly unreasonable. In the case of Riley, the Court of Appeal in Northern Ireland said ultimately the question whether procedural fairness requires their deliberations to include an oral hearing must be a matter of judgment for the board. Your Lordship said these dicta might be read as suggesting that the question whether procedural fairness requires an oral hearing is a matter of judgment for the board, reviewable by the court only on Wednesbury grounds. That is not correct. The court must determine for itself whether a fair procedure was followed. Your Lordship refers to Lord Hope's observation in the Gillis case. That's the court's function, is not merely to review the reasonableness of the decision maker's judgment of what fairness required. And that's my submission. I say we are here concerned with a statutory right of appeal. This case concerns what that statutory right of appeal requires as a matter of basic elementary procedural fairness. And I will submit, and I'm coming to this, we're not on the margins here. We are concerned with fundamental restrictions, inhibitions, inabilities in relation to the meaningful right of appeal for Ms. Begum. Sir James made a submission this morning. He made the submission in the Court of Appeal as well. Essentially, although he put it much more eloquently, but the submission came to this: it's all Miss Begum's own fault. She should not have gone to Syria in the first place, and she is the author of her own misfortune. Now, in my submission, that is, with respect, no answer to the statutory right of appeal which she enjoys, the right to a meaningful right of appeal. It's not suggested in this case. One can envisage hypothetical cases where when the right of appeal arises, when the deprivation order is made, hypothetically one could imagine somebody hiding themselves away, avoiding service of the notice and the reasons. But that's not this case. Miss Begum wants to appeal. She wants to exercise a meaningful right of appeal. And in any event, the submission that Sir James made was rejected by Lord Justice Flo for the Court of Appeal, in my submission, in correct terms. This was at paragraph 94 of the judgment, which appears at page 276. Page 276, paragraph 94, refers to my friends placing considerable emphasis on Miss Begum having left the UK of her own free will to go to Syria. She aligned herself with ISIL. She remained there for 4 years until her detention by the SDF, so that, this is the submission, the difficulties she faces in terms of presenting her appeal are to a large extent self-inflicted. However, as Sir James recognised, the cases which have considered this question of absence from the jurisdiction being self-inflicted, GI, that's K2 and S1, so G1, K2 and S1, have done so in the context of the issue of whether the relevant appellant can have a fair and effective appeal, an issue which in the present case has been determined in Miss Begum's favour. None of them, that's the other cases, has considered the legal and procedural consequences of an appellant not being able to have a fair and effective appeal, the issue which arises in the present case. In his lordship's judgment, the circumstances in which Miss Begum left the UK and remained in Syria, and whether she did so of her own free will, should be irrelevant to the question of the legal and procedural consequences of the conclusion by SIAC that she cannot have a fair and effective appeal. His lordship would be uneasy taking a course which in effect involved deciding that Miss Begum had left the UK as a 15-year-old schoolgirl of her own free will in circumstances where one of the principal reasons why she cannot have a fair and effective appeal is her inability to give proper instructions or provide evidence. One of the topics that could be explored on her appeal before SIAC, I would submit will be explored, is precisely what were the circumstances in which she left the UK in 2015, but that could only properly be determined after a fair and effective appeal. the Secretary of State's submission risks putting the cart before the horse. My only quarrel with that is the word risk. It does put the cart before the horse. Miss Begum, on her appeal, will no doubt wish to present her side of the case and explain the circumstances in which she left this country in 2015. This court cannot, in my respectful submission, speculate on what the circumstances were and what conclusions SIAC may reach in relation to them. That's the purpose of the appeal. Equally, in my respectful submission, the court cannot speculate on what Miss Begum's evidence will be in relation to why she remained in Syria with ISIL for the best part of 4 years. One can easily think of circumstances that she may, I emphasize may because I have no instructions from her, but the circumstances in which that she may advance relating, for example, to the inability to leave, the pressure she was under, the violence that was inflicted on people who were there, who in any way challenged authority. That may well be an important part of her case. This court cannot prejudge any of that. That's the purpose of the appeal. Equally, Sir James this morning drew attention to the newspaper interviews that were given by Miss Begum. Again, it may well be part of her evidence at the appeal to explain the circumstances in which she gave those interviews. She may well say that to be in any way critical of ISIL at that time would have endangered her safety, her life. The court cannot prejudge those issues. Again, that is the purpose of the appeal, to give her a proper opportunity to present her case, both in answer to the allegations that are made by the Secretary of State, and for her to adduce such exonerating or mitigating material as she and those advising her think appropriate. And Sir James's theme, it's all her own fault, in my respectful submission, puts the cart before the horse for precisely those reasons. It is, if I may respectfully say so, also important to address this issue of Miss Begum's inability, and I'm coming to why I say it's an inability, her inability to play a meaningful part in her appeal in the context of the Secretary of State's understanding at the time when he made the deprivation decision. Can I invite your lordships and your ladyship to go back to the open summary of deprivation submission, which appears at EF 369. And my friend Sir James drew attention this morning to some parts of paragraph 3. Could I invite attention, please, to page 370, letter H. And it's the first sentence of letter H. I'll deal with the rest of it when I come to the substance of national security. But can I just invite the court's attention to letter H? SCU, that's the Special Cases Unit, considers that should Begum become aware of the deprivation decision whilst in Al-Hol, it is difficult to see how she might effectively exercise her appeal right from that location. Now, it is true that that statement was made when Miss Begum was in the Al Hall camp. She's since moved to Al Rock, and as I shall submit, the same point arises in relation to Al Rock. But it is of some interest, at least, some significance, that when the then Home Secretary, it's not the current Home Secretary, when the then Home Secretary, Mr. Sajid Javid, made the deprivation decision, he did so on the basis of advice that it was difficult to see how Miss Begum might effectively exercise her appeal right. It's really not very surprising in the light of that SIAC reached the conclusion they did in the paragraph to which I have already drawn attention. It's also when SIAC made the finding that they made that Miss Begum at that time, at the very least, could not enjoy an effective right of appeal. While I have that page open, it is also of some interest that at page 370, slightly higher up, letter E, the SCU, the Special Cases Unit, also notes that individuals such as Begum, who were radicalized whilst minors, may be considered victims. They do go on then, I don't wish to mislead the court, they do then go on to recognize or to assert that this does not, in their view, affect the threat that they pose. But it is of some importance what they say in the first sentence, because again, when SIAC hears the appeal, they will wish to hear what Miss Begum has to say as to the circumstances in which she went to Syria in the first place, and also we draw attention to the fact that the written submissions made by Liberty draw attention at paragraph 10. I don't ask the court to turn it up. It's EF 208 to 209, that the Secretary of State herself has duties to protect victims of trafficking for the purposes of modern slavery. And whether and to what extent the circumstances in which Miss Begum travelled to Syria, and indeed the circumstances in which, as a minor, she remained there, attract this type of concern and this type of protection, are matters that cannot be determined on this appeal. Again, it is the purpose of the substantive appeal which Parliament has conferred on Miss Begum. The next topic I wanted to turn to, my lords, my lady, this afternoon in the time that remains, is to address the question of whether the Court of Appeal was correct to find that Miss Begum cannot now enjoy a meaningful appeal. And the Court of Appeal addressed this question at page 276.
Lord Panic, just before we embark on this, can I just mention a matter in case it's of any significance, and you might want to come back to it if it were.
Yes,
it just relates to this issue I was interested in earlier of the nature of a jurisdiction exercised by SIAC. Lord Wilson in Al Jeddah was speaking about review on appeal of whether deprivation of nationality would render a person stateless, and there was an agreed position as to what the role of SIAC was. In relation to assessment of what national security requires, I see that there's a rather more sophisticated analysis by Lord Hoffman, with which other members of a majority of members of the committee agreed in a case called, which Lord Sales, I think, was in as counsel, called Home Secretary and Raymond, which is reported in 2003, One Appeal Cases 153, which indicates that some aspects of the decision are for SIAC to consider for itself, and other aspects are for the Secretary of State. So I just mentioned that for the sake of completeness, in case there's anything there you want to come back to.
Well, I'm very grateful. Can I look at that overnight?
Yes, of course.
My Lord, and make my submissions tomorrow morning on that. That's it's a 2003 case, so whether it remains.
Oh, no. I noticed it wasn't cited. It wasn't cited to Lord Wilson, and I don't know what its current status is.
No. Well, we will look at that. Thank you, my Lord. I will certainly look at that and come back to it tomorrow morning. In relation to whether Ms. Begum can now enjoy a meaningful appeal, at page 276 of the bundle, at paragraph 92, the Court of Appeal set out the first sentence of SIAC's judgment at 143, quote, "We accept that in her current circumstances, she cannot play any meaningful part in her appeal, and to that extent, the appeal will not be fair and effective." And the Court of Appeal says, and we respectfully adopt their view, this is in clear and categorical terms. What in current circumstances means is that while she's detained by the SDF in a camp, which as matters stand is for an indefinite period, of course, when later in the judgment they discussed the possibility of her applying for a stay in the hope that at some point in the future she would be in a better position to take part in it, it was recognising that at some indeterminate point in the future she may no longer be detained by the SDF, but on the findings made, that is entirely speculative. We would respectfully agree. It is, of course, theoretically possible that the difficulties under which she was operating and those advising her were operating as at the date of the SIAC determination may be removed at some later date. But there was no evidence before SIAC that that was the case 1 year after SIAC, 1 year after she had entered the Al Roj camp, which was in February 2019. SIAC heard the matter in, I think, October 2019, yes, and they gave judgment on the 7th of February 2020. And the court is entitled to infer that if the Secretary of State had any fresh material prior to the 7th of February, she would have informed SIAC of it. So that was the position as at that time. At 93, His Lordship says he does not accept the submission on behalf of the Secretary of State that SIAC was only expressing a provisional or pro tem view about Ms. Begum's prospects of playing any meaningful part in her appeal while she's still detained. Although SIAC does not refer expressly at this point in its judgment to the evidence of Mr. Ferner on behalf of Ms. Begum as to the difficulties of communication and of obtaining instruction, its conclusion in the first sentence of 143 seems to His Lordship to show that it is accepted, that it accepted that evidence which was unchallenged. I agree with Mr. Hickman, then arguing all of the case for Ms. Begum, that in circumstances where the Secretary of State has not cross-appealed the conclusion in the first sentence of the judgment or sought to challenge through cross-examination the evidence of Mr. Furner, it's not open to the Secretary of State to run arguments such as that Miss Begum's situation in the camp might be susceptible to immediate change because she might gain access to a telephone or a video link, or that she can give instructions, albeit in an attenuated form. We have to proceed on the basis that while she remains detained in the camp, she cannot give effective instructions or take any meaningful part in her appeal, so that, as SIAC found, the appeal cannot be fair and effective. Now, I emphasise, I'm not taking a technical point here. I am submitting that there was no material before SIAC which undermines the conclusion that it reached in the sentence that is repeated at the beginning of 92. Indeed, all of the evidence supported what SIAC said. There was no change by the time of the judgment of SIAC, and there's no material I submit, and I'm not going to go into evidence in detail, but I submit that there's no evidence before this court that undermines that conclusion. What I am going to do is to show the court the material that was before SIAC, because the judgment of the Court of Appeal does not go into that evidence, and does not do so because there was no cross appeal before the Court of Appeal on that point. And I've already made the submission. I won't ask the court to go back to it, but I've already made the submission that paragraph 3, subparagraph H of the ministerial submission, which was at page 370, expressly recognised how difficult it would be for Miss Begum effectively to exercise her right of appeal from the camp that she was then in. So I will invite the court to look at the material placed before SIAC by Mr. Furner on behalf of Miss Begum, most of which is open material. There's some of it which is confidential material, which I shall simply direct attention to, but most of it is open material. The redacted open version is at Appendix Part 3, EF 1440. This is the redacted version of Mr. Furner's witness statement, an open statement, and the court will see at page 1443 and 144 that what has been redacted is paragraphs 18 to 23 and 26 to 27. Those are the redacted paragraphs. The rest of it is open. The confidential paragraphs 18 to 23 and 26 to 27 are in your lordship's bundles in the confidential, the closed witness statement, the same witness statement but in closed terms, which is at page 398. And the relevant paragraphs start at page 401, that is 18 to 23 and 26 to 27. I was going to start, and I'm not going to take very long on this, but I'm going to take longer than the minute or 2 minutes available this evening. That may be a convenient moment if it pleases the court to break now. We're making, I think, in temporal terms, good progress in this case.
Yes, thank you very much. Well, in that case, we'll adjourn now for the day and resume the hearing at 10:30 tomorrow morning.
Thank you
all
very
very
much, my lords and ladies. Thank you.